I'm not sure whether everybody can hear me, so if that is so, I could start. Niti, is that all right with you? Wonderful. Okay, so I get several responses, and I think everybody can hear me, so I start with my lecture. I'm supposed to talk about the impact of COVID-19 on German insolvency law. And before we come to the legal solutions, we should face the economic problem. I think these problems are the same in all over the world. Businesses are closed, and that means companies don't have any customers, they don't have any turnover. On the other side, expenses keep running, and that means that there is a lag between expenses and income. Most companies don't have sufficient reserves to bridge this gap for a longer time. So the question is how to finance the enterprise during the COVID-19 crisis. One solution could be to get bridge loans from banks, but they are very reluctant to offer such loans because insolvency of the debtor is looming, and mostly there is no collateral available to establish security rights. And what is more, security rights might be subject to transactions avoidance law after the opening of insolvency proceedings. Not only banks, but also investors are reluctant to buy companies and put money into the enterprise. And that means we have, I think, worldwide problem how to deal with the COVID-19 problems as far as the economic situation is concerned. So what are possible solutions which we can find all over the world? First solution would be that the state grants loans to the enterprises. Another solution would be to protect especially employees with social security means. And there may also be legal remedies in contract law, company law, and insolvency law. And if we compare various jurisdictions at the current stage, we can see that all these remedies are available in most jurisdictions. So what are the solutions in Germany? First of all, we had an act which granted a supplement to the federal budget. In Germany, our constitution hinders the government to spend as much money as they want. There's a limit, and this limit for indebtedness of the state has now been extended for another 156 billion euros. So it was a first step. A second step was to establish an economic stabilization fund. And the task of this fund is to grant either guarantees to safeguard loans given by banks, or to grant money directly by mezzanine financing for big non-financial enterprises. So non-financial enterprises are all enterprises except banks and insurance companies. But the prerequisite is that these enterprises have systemic relevance. So they are, to use a common slogan, too big to fail, which is true, for example, for companies in the area of internet, telephone, commuting, so railway companies and so on. And then there is a fund of another 50 billion euros to grant basic support for micro, small, and medium enterprises and self-employed persons. they can quite formally apply for grants of 9,000 euros if you have less than 5 employees, or 15,000 euros if you have more than 5 employees. And this money is sort of a gift. It is a lump sum which is granted by the state just as a bridge. It's not a loan. It needs not to be paid back. So that are financial means. We see that there is an extensive loan program which is managed by the German Development Bank. We have also an expansion of short-time work. That is a very special social security mean protecting employees against losing their jobs. The employer is not urged to set the employees free, but can rather put them on what we call short-time work. And that means there's a compensation instead of employment fees, a compensation paid by the Federal Employment Agency. So people do not have to work on the one hand, but get money up to 80% on the other hand. We have a special program financing our hospitals, which are essential in a pandemic crisis. And then we have also a bundle of legal remedies, and I think I should switch over now to the legal remedies in Germany. There was very quickly after realizing that the pandemic needs significant measures, there was an act on mitigation of the consequences of COVID-19 pandemic in civil, insolvency, and criminal procedure law. And Article 1 of this act is another act, the act on temporary suspension of the duty to file for insolvency proceedings and on limitation of directors' liability in an insolvency caused by COVID-19 pandemic. It's a so-called Provinz AG. This law, the statute, has a very strange title, which is not understandable for people outside Germany. And even in Germany, it's only understandable for people who are experts in insolvency law. So I think I should explain it step by step. Let's first talk a little bit about the objective of this Provinz AG. The objective is to enable and encourage directors and entrepreneurs to continue business wherever possible, and also to encourage business partners to continue business with the company which faces financial difficulties. The law also intends to encourage lenders to grant new credit and to protect in itself viable businesses against insolvency caused by the pandemic by granting a suspension period. And my main topic in this webinar should be the suspension period, its definition, and its consequences in insolvency law. If we come back to the title of the statute, I already mentioned it's an act on temporary suspension of the duty to file for insolvency proceedings. And this title comprises the word suspension, and we should switch over to the question, what does this mean? In our insolvency statute, it's called Insolvenzordnung, or in English, insolvency regulation. We have a section 15a, and this section 15a contains this duty to file for insolvency proceedings once the company is substantively insolvent. The text reads, where a legal person becomes illiquid or over-indebted, the members of the board of directors or the liquidators shall file a request for the opening of proceedings without culpable delay, at the latest, however, 3 weeks after the commencement of insolvency or over indebtedness. This is the official translation of our government. I think it's not very precise, but I will try to explain the details to you. So what are the prerequisites for the duty to file for insolvency in Germany? First, the company must be a legal person. Nearly always it's a limited liability company. GmbH is the abbreviation in Germany. A limited liability company, which is a legal person, and the directors of this company, sort of company, are addressees of the duty to file. What is the next prerequisite? The company must be substantively insolvent, and in Germany we have 2 cases of substantive insolvency. The first is very well known to most other jurisdictions. It's the inability to pay debts. And the other one is over-indebtedness. Both are described in our insolvency regulation. So once the company is substantively, excuse me, substantively insolvent, the directors have 3 weeks to try to rescue the company, to abolish insolvency, and to get new money and restructure the company. 3 weeks is not very much, but if you get a loan bridge from your bank big enough to finance restructuring efforts, then possibly the substantive insolvency is abolished and the duty to file does no longer exist. So you have 3 weeks to try to avoid insolvency proceedings. If that is not successful, then you have to file for insolvency proceedings. And what are the sanctions? Sanctions if the directors do not oblige to this legal command. The sanctions is, on the one hand, personal liability of the directors for damages. So they have to pay what the creditors lose as a result of not filing in time. And the second consequence is that the directors commit a criminal offense if they don't file in time, and that means that are very harsh sanctions for the directors. I must admit that despite these sanctions, the duty to file for insolvency proceedings is quite often neglected in Germany. It mostly or quite often turns out that companies are unable to pay their debts when they fall due for, let's say, 1.5 or 2 years before filing for insolvency proceedings. And that raises the questions, why is that directors do neglect this duty? I think the answer is a psychological one. The directors are the last to realize that they are substantively insolvent, and that leads them to closing their eyes and not realizing the insolvency. When talking about insolvency in the context of COVID-19 statutes, we should turn briefly to the term illiquidity, which is defined in section 17 of our insolvency regulation. Illiquidity is the same as inability to pay debts when they fall due, or a word that is used in other jurisdictions, cash flow insolvency. And in our context, the question arises, which debts are due, and does the COVID-19 statute change anything concerning cash flow insolvency? And the answer to some extent is yes, because the COVID-19 law establishes or grants a temporary moratorium, albeit in contract law only. And if we take a closer look to this temporary moratorium, we must first ask, what is this moratorium? And maybe to your surprise, it is not an enforcement ban. Normally, in the insolvency law context, we connect the word moratorium with an enforcement ban for creditors. We don't have that in our COVID-19 law. The moratorium is only a remedy in contract law, and it grants the right to withhold the performance or counter-performance of the debtor for essential continuing obligations. One example for that is tenancy agreements. Another consequence of the moratorium is that monthly credit installments do not become due, which is a deviation to the normal situation under the loan agreement. But this moratorium is only granted, and now we have three conditions, where the contract was concluded before 1 March 2020. And you may ask, why 1 March 2020? Well, the answer is that our legislator decided this was the legal beginning of the pandemic in Germany, which is, you may smile on this, but you have to find a certain date. So they decided on 1 March 2020 being the decisive day for granting protection against the economic consequences of the pandemic. So that is the first condition. The second is the moratorium does only effect obligations when a payment would endanger the existence of the debtor. So where there is enough money to pay the rent or to pay credit installments, the moratorium does not come into force for this very debtor. And the third condition is that the situation must have been caused by the pandemic. And that is a very important decision of our legislator. When the company was insolvent, no matter whether there is a pandemic or not, then there is no protection at all, neither in contract law nor in company law. There's another consequence of the moratorium. Lenders and landlords are excluded from their termination rights. So on the one hand, they don't get money because there is this moratorium. And on the other hand, they can't take this as a reason for terminating the contracts, which is, I think, a reasonable complementary remedy within this moratorium. So maybe you are now thinking this moratorium is a very good idea, but this moratorium is only for consumers and micro enterprises, so let's say for startups. It's not available for small and medium enterprises, and certainly not for bigger enterprises. So in our context, I think the relevance of this moratorium is very small, and I will not come back to it during this webinar. But I have to come back to the duty to file for insolvency proceedings established for companies which are substantively insolvent by the Provinz AG, which I mentioned at the beginning of my webinar. To file is suspended for the period of 1 March to 30 September 2020. So as I said, 1 March is the day the legislator decided that that was the beginning of the consequences of the pandemic in Germany, and 30 September is the day which the legislator thinks will be the end of the economic results of the pandemic. Maybe the legislator was wrong with this prognosis, but there is an entitlement for the government to prolong this period, the suspension period, when there is need to do so. For the time being, the suspension period is 1 March to 30 September. This suspension period covers all companies which are substantively insolvent unless, and now you see that we come back to the connection with the pandemic, unless insolvency is not caused by the COVID-19 pandemic, or there are no prospects to eradicate the inability to pay debt. So what we see here is that our legislator established special protection for companies which have a reasonable prospect to be restructured to survive the economic consequences of the pandemic. Not all insolvent companies get the protection by the COVID-19 statutes. Only those where insolvency is caused by the pandemic and where there is a reasonable prospect to eradicate the substantive insolvency. So one difficult problem is how can we establish that the insolvency is caused by COVID-19 pandemic and that the prospects are there to eradicate the substantive insolvency. This is difficult to establish, and therefore the legislator decided to establish a rebuttable presumption that these conditions are met, so that insolvency is caused by the pandemic and that there are prospects to eradicate inability to pay debts, but only, well, this presumption is only granted where the debtor was not illiquid on by the end of last year on 31 December 2019. So what are the legal consequences of this suspension period? I mentioned one, the duty is to file is suspended, but there are other legal consequences which we should take a closer look to. And I will start with the duty to file. Again, we can do that briefly because I have mentioned most part of it. I think, especially for listeners and spectators, for an audience from India, it might be helpful to stress that only the duty to file is suspended. So directors are not obliged to file where they would be without the protective rules of the Covenants AG. But they are not hindered to file for insolvency. So an application by the debtor to file for insolvency or an application for insolvency proceedings is still permissible, and that is very important under German law because we don't have so far a special statute on restructuring law outside insolvency proceedings. So in Germany, if you want to restructure your company, you must either do that by negotiating out of court with your creditors, or you must use insolvency proceedings to get protection by insolvency law, which enables you to restructure your company. So it is very important under German law that insolvency proceedings are still permissible, because that opens the opportunity for debtors to enter insolvency proceedings, to file for insolvency proceedings with the aim to restructure the company by means of insolvency law. So we have not decided, and I think it's wise not to decide so under German law, I'm far from giving advice to other jurisdictions because there might be national peculiarities which I cannot judge. I don't know them. I cannot put them in the right context. But under German law, it's important not to prohibit all insolvency proceedings and only give the directors the chance to wait until the end of the pandemic before deciding should we enter insolvency proceedings or not. But if they make this decision now, they have the permission to do so. And what is only possible is a creditor's application. In Germany, insolvency proceeding can be initiated either by the debtor or by any creditor. And the right for creditors to apply for insolvency proceedings over the estate of their debtors is not hindered at all, but those insolvency proceedings will not be opened where the filing has reached the court between 28 January and 28 June 2020. Also, this period can be prolongated. Unless the debtor was already insolvent on 1 March 2020. So if the debtor was insolvent before this day, then creditors can file for insolvency proceeding without any restrictions by the COVID-19 statute. If the insolvency occurred after this day, then creditors may apply for insolvency proceedings, but this application will not be dealt with by the court before 28 June 2020. And my guess is that this protection period will also be prolongated by the decision of our government within the next weeks. So much on the duty to file for insolvency proceedings. The next point is also a very important one in the context of insolvency law. Under the German Act on Limited Liability Companies, our GmbH, the directors are obliged to compensate the company for payments made after the company has become illiquid or after it is deemed to be over-indebted. And this shall not apply to payments which after this point in time are compatible with the due care of a prudent businessman. If you want take a closer look to this rule, then the prerequisites are that a limited liability company must be substantively insolvent. And again, this may be illiquidity, inability to pay debts, but it may also be over-indebtedness. And when in this stage of the company, a director pays a creditor, then the consequence is that the company may claim compensation by the director, him or herself. She has or he has to pay, to reimburse the money that was paid from the company's estate to the creditors. And there is only one exception, and that exception is if the payment is compatible with the due care of a prudent businessman, then there is no obligation for reimbursement to the company. So the decisive question is, what is compatible with the due care of a prudent businessman? And the answer is, if you pay suppliers which you need for continuing your company, if you pay taxes or social security for your employees, if you pay money to the employees because you need the work of the employees, then this is compatible with the due care of a prudent businessman. But if you pay creditors who have debts which are outstanding for a long time, then it is not prudent to pay them because they should wait until insolvency proceedings have been opened. So of course the devil is in the detail, but that may suffice for today. So what does the Provinz AG, our COVID-19 law, say about this personal liability of directors? The answer is during the suspension period, so during the time where the duty to file is suspended, payments are irrefutably deemed compatible with the due care of a prudent businessman. So it is, there's a presumption, and it's an irrefutable presumption that all payments are compatible with the due care of a prudent businessman, which means the directors are not obliged to compensate the company. But there is a condition, and this condition is that the payment is made in the ordinary course of business. And this term, ordinary course of business, is defined in more detail. The law says particularly where the payment is destined for upholding or resuming business operations and or implementing a restructuring concept. So we again see this remedy is not for companies which are helplessly insolvent, because if you are helplessly insolvent, then you don't get the suspension period. All prerequisites of the suspension period must be fulfilled, not only for the delay of the duty to file for insolvency proceedings, but also for the liability for payments. And only payments which are necessary to uphold the business and to implement a restructuring concept, so all payments which are necessary to maintain the business and to meet the conditions for rescuing the company are permissible. So that is the second consequence after the duty to file, suspension of the duty to file, and the suspension of the liability for payments. There's a third consequence or bundle of consequences which concerns transactions avoidance law. And I'm afraid I must give you some basic information. I will not hold a lecture on transactions avoidance law. We don't have the time for that. But if we just face the basics of German transactions avoidance law, we have firstly general prerequisites. You can only avoid, after the opening of insolvency proceedings, transactions which have been performed prior to the opening of insolvency proceedings and which are detrimental to the general body of creditors. These prerequisites are normally met in our context because all payments in our context have been performed prior to the opening of insolvency proceedings, and payments are always detrimental to the general body of creditors because this money is now in opened insolvency proceedings is now missing. But this is not enough, because if that would suffice, you could challenge all payments prior to the opening of insolvency proceedings. What is necessary in addition, and that holds true, I think, for nearly all jurisdictions, at least those jurisdictions I'm familiar with, you need avoidance grounds, and these avoidance grounds are, in German terminology, I will explain that in a second, congruent or incongruent coverages. That is what in other jurisdictions is called preferences. And second, transactions at an undervalue. I think you are familiar with this expression. And thirdly, transactions defrauding creditors. So I should give, just let me see, I should give a small introduction into the avoidance privileges for new loans. There's one paragraph of the Provinz AG number 2 of section 2, paragraph 1, which protects what we could call fresh money. This paragraph grants protection against transactions avoidance if payments or security rights are granted for new credit during the period where the duty to file is suspended. So if a bank or a private person gives a loan during the period between 1 March and 30 September 2020, then we can speak of new credit, and this includes granting security rights for such new credit, but only if this security right is not granted by a shareholder. So unprotected, unsecured loans given by a shareholder are included in this paragraph, but not security rights. So what is the consequence? Repayments or collateralization is in future insolvency proceedings, if applied for before 30 September 2023, irrefutable deemed not to be detrimental to the general body of creditors. And that refers, let me go back one slide, to the general prerequisite that transactions must be detrimental to the general body of creditors. If they are not, they cannot be challenged in insolvency proceedings. So the legal technique of section 2 referring to new loans, fresh money, is that repayments or collateralization for such new money is deemed not to be detrimental to the general body of creditors. So that is a very specialized protection. We have more general protection concerning payments to other creditors. For example, payments to employees, payments to landlords, payments to suppliers. And before I can explain the technique of the COVID-19 statute, I should mention in 2 or 3 words what does our transactions avoidance law say about such payments. And such payments can be congruent coverages, what we call congruent coverages, and they can be challenged if there are coverages, and coverages are satisfaction or collateralization of claims. This payments or collateralization must have been made to the benefit of an ordinary unsecured creditors. And now the decisive point is the creditor must have been entitled to exactly this transaction. So if he gets something he was not entitled to, it's not a congruent, but an incongruent coverage. I will come to that in a second. You can only challenge payment or collateralization which has been performed 3 months prior to the application for insolvency proceedings. So there's a very short suspect period. And you can only challenge the transaction if the debtor was already unable to pay due debts. And a last prerequisite is that the creditor must have known of the debtor's inability to pay debt. So if these prerequisites are met, and you see it's a very narrow section in our insolvency law, then payments to creditors are challengeable in opened insolvency proceedings. The situation is a bit better for the insolvency practitioner who wants to challenge satisfaction or collateralization of creditors if the coverage is incongruent. So If we have a coverage, again, this is satisfaction or collateralization of claims, benefiting an ordinary unsecured creditors during the suspect period 3 months prior to the application for insolvency proceedings, and where this coverage is incongruent, that means the creditor was not entitled to exactly this transaction where the creditor got the payment earlier, or where he got not the same which was promised in the underlying contract, then the transaction is incongruent and can be challenged without any subjective requirements, mental elements, provided that the debtor was unable to pay debt. So that makes it easier because there's no need to establish knowledge of the counterparty. It makes it easier for the insolvency practitioner to challenge such coverages. And how does now the COVID-19 law interfere in this transactions in avoidance law? The law addresses congruent coverages and certain, not all, but certain enumerated common typical incongruent coverages, example given payments by third parties. This must be performed during, now again, the period where the duty to file was suspended. That is a suspension period of 1 March to 30 September, provided in this suspension period the company was not helplessly insolvent and the insolvency was a result of the COVID-19 pandemic. If the creditor had no knowledge of the debtor's efforts to restructure or finance the business, being inept to resolve the inability to pay debts, mostly we don't have a suspension period in this under these conditions, then the repayment or collateralization is not challengeable. So we see contract partners are encouraged not to terminate their contracts and to accept money from the debtor company, even if they know the debtor company is insolvent, and thereby to support the rescuing efforts of the company and its directors. So we see that as a third very important remedy to encourage restructuring efforts during the pandemic, during the suspension period I was talking about. So a last legal consequence concerns a very special point. Granting credit and securities can be acting contra bonus mores under German law. That is the case if other creditors are intentionally deceived about the debtor's creditworthiness. If we have a collaboration of a bank and a debtor by granting insufficient credit for resolving the debtor's insolvency. And that very special case is not valid, is not a valid defense, where the secured credit was granted during the period where the duty to file was suspended. Here again, the fear to be confronted with the legal defense granting the credit was against contra bonus mores, which would have the consequence that the contract is no longer valid and the bank is liable for damages against other creditors. This fear should be avoided by interfering with the COVID-19 statute. So that was what I have prepared for you. If you want to learn more about the German COVID-19 statutes, then you can find more information on a website provided by Insol International. This link leads you to an interactive map of the World Bank, and you can now click on certain countries and get national reports from that. So many thanks for your attention. I'm now happy to receive questions, and I already see a first question here. So if you are so kind to place your question in the chat button, or then I could give you an oral answer to your question, but you may also try. So here I have the first question. What is the past experience of guaranteed loans to small businesses? Are they paid back by the small businesses? What has been the recovery rate, and what are the repercussions if a healthy business is not paying when the loan is due? So I take it this question is referring to our to the pandemic situation. Outside this situation, I think we don't have special problems with small businesses. I think the recovery rate is nearly the same as it is with other companies. And of course, they don't have so much assets, so the recovery rate might be smaller compared to big companies, but we don't see a special insolvency law problem here. But I think I can say that the government tried to address the problem of micro, small, and medium enterprises in this COVID-19 statute, as explained by me, but they don't think so far that there is a special problem which should be addressed in a very special way. For example, as I explained, the moratorium is not available for small businesses. Okay, thank you for this question. Is there another one? Can you please elaborate on the role of an insolvency professional in insolvency law in Germany? Well, in Germany, the insolvency professional has a very strong position. In Germany, debtor in possession proceedings are an exception. Normally, the insolvency professional is responsible for the estate and for paying the creditors. So in my view, that is a very strong position. Neither the court nor the creditor committees can interfere in the decisions of the insolvency professional. The only thing is that he is liable for all mistakes which occur during the handling of the case. The next question is, since this law has come into place, has there been a decrease in the number of SMEs that have been brought to insolvency proceeding? Actually, I can't answer that question. We don't have any numbers. We have further applications for insolvency proceedings after the coming into force of this law. And there, of course, are some SMEs among the debtors applying for insolvency proceedings. And I think the reason for that is not that these are helpless insolvency cases. The reason is that you get special social protection for your employees. During 3 months after the application for insolvency proceedings, the employees are paid by a special state-run insolvency insurance. And that is why applying for insolvency proceedings increases your chances for restructuring, because your employees are paid by the state. You can employ them, you can continue to make use of their work, but you're not obliged to pay them because they are paid by these insurance payments. And that is why we have various insolvency applications even after the COVID-19 law coming into force. So next question is, which consequences arises from COVID-19 falls in the ambit of force majeure? I must admit I cannot really answer this question. I do not understand what it is aiming at. Force majeure, of course, is a problem, and it may be used when it comes to is there an obligation to fulfill your contract? You are not obliged if there is force majeure, and some authors are publishing the opinion that COVID-19 falls in this category of contract law, but that is not established by courts so far. What is the role of the central bank to keep loan recovery from MSMEs? There's no role at all, because we have this special state-run bank, which I mentioned in my lecture. All loans are coming from them, and they are trying to provide fresh money for SMEs. Yeah, that's the question so far. Are there further questions? I would be happy to answer them. I have time enough.
Professor Bork, I had a question.
Yes, please do.
I wanted to know your views on, the countries that has not suspended directors' duties for fraudulent transaction. Do you think there's any gains or losses for those countries?
That's difficult to answer for me, because most countries don't have the obligation to file. They have other remedies like directors' duties concerning fraudulent transactions in the in the period prior to insolvency proceedings, and I think many countries have interfered in this law and have suspended the duties in the period prior to insolvency. But I have no complete oversight, and I have no figures about the question whether, or as to the question whether these remedies work or work not. Do you have any insight from India?
So India, in India, we have not suspended the directors' duties, and directors are not exonerated from any obligation. Interestingly, we have Section 166, which makes directors duty bound towards stakeholders as well as creditors and shareholders. And unlike the UK law, the English law, there's no legislative guidance in India as to who has to give the priority. So if I were to read in light of the latest directions from the government, it seems that stakeholders will take a primacy. And so even in a case where director has given preference to stakeholders' interest and taken a decision, I don't see it really making a case for creditors to sue them later. Having said that, it's interesting to know that there are many countries, in fact, most of the countries have suspended wrongful trading and fraudulent trading so that directors can risk and restructure their companies in the best interest.
Yes, that is a very interesting remark, because we have to answer the question, who is the person to be protected by these special pandemia laws? For example, if we have a privilege against transactions avoidance, this on first sight seems to privilege creditors, but that is not true. It's not about protecting creditors, it's about protecting the company against the creditors refusing to do further business with the company. So protecting the creditors is only a means for the main goal, protecting the company. I think we have the same in many jurisdictions. So thank you for pointing this out. The question, who is the person to be protected by COVID-19 laws, is a very interesting one.
Yeah. We have one more question, Professor Bork, in the dialogue. Susan has asked a question. Just to share with you, Ms. Susan Thomas was also the member of the Banking Law Reform Committee that the government had made. She asked, there's an observation that several firms have applied for insolvency proceedings to avail of the employee insurance. For how long can the insurance be availed of?
It's 3 months.
3 months.
3 months. Does the availability of insurance only last for the period of a moratorium? The answer is no, because this is a general insolvency law in Germany. This protection for employees by the special insurance is a remedy we have in Germany for over 30 years, I think. And it has nothing to do with the pandemia. So what happens to the insolvency proceeding after that date? Well, you should have finished your restructuring plan and get it accepted by the creditors' assemblies. Otherwise, you must have enough money to pay your employees yourself. So it's only for 3 months. And only for the period prior to the opening of insolvency proceedings. So it's an insurance protection for the application phase, not for opened insolvency proceedings. There's another question with respect to the ongoing insolvency resolution cases. What happens where the debtor is unable to make payments to the contractor suppliers during the process, which is otherwise required to make under law? It will affect the insolvency professional's ability to maintain the debtor as a going concern. Yes, it does. So that is a problem I think we have also outside our current pandemia problems. You can only rescue a company if you have enough money to keep the business running. And you have to negotiate with the most important contract partners and to ask them for a moratorium or for a waiver of claims. And if you cannot get that, at least from the majority, you will not be able to establish an insolvency plan to rescue the company. That problem may be tougher under the current conditions, but it's a general problem.
Thank you, Professor Bork, for answering most of the questions. There's another question that I had. In the meantime, if the viewers want to post any further questions, please feel free to do so. Professor Bork, I wanted to ask you that, how do you see the difference in, between suspension of the rights of landlords as a part of the COVID Act or deferment? As I understand, Singapore has only deferred the rights but does not suspend the rights. And as I saw your slides, I understand that the rights for the landlords are terminated. Is it so? In Germany?
Yes, in Germany we have no protection only for consumers and micro enterprises. All others have either to negotiate with the landlord or go under the protection of insolvency law. So they have to apply for insolvency proceedings. There's no special protection by the COVID-19 legislation.
Right. I think we have another question here.
Yeah. So in Germany, COVID-19 justice package covers the suspension of the obligation to file for insolvency until 30 September. The suspension does not apply if the insolvency is not a consequence of the COVID-19 pandemic. In India, the government has decided to amend the insolvency law to suspend up to 1-year provisions that trigger insolvency proceedings against defaulters, irrespective of its cause, whether it is related to COVID-19 or not. What's your view on these two different approaches? Well, my view may be handled very carefully because I do not know anything about the circumstances in India, the legal environment. But it seems to me that entering insolvency proceedings may be helpful for restructuring. It may give you a moratorium of insolvency law against all creditors. And so, at least from the German perspective, it may be helpful to let this possibility to enter insolvency proceedings and get the remedies and helps and means of insolvency law. It seems to be, to me, it seems to be preferable, but that may be different from an Indian point of view. I read an article in the Oxford Commercial Law blog of an Indian lawyer who opposed this Indian way, and he wrote that it might not be very helpful to suspend all insolvency proceedings, no matter whether they are caused by the pandemic or not. I share this view, but maybe I do not know enough about Indian insolvency law.
Just to add to that, Professor Bork, I also am of minority view that suspension should not be there, especially blanket suspension. And we intend to organize one webinar, which will be a panel discussion with some leading industry experts in India. So Aditya, my request is do stay tuned to our social media and our website. And hopefully next week, we intend to organize one webinar around this issue so that we can deliberate it further. Yeah.
Okay.
So any further questions? Yes, sir. Sorry.
You would prefer me to log into this webinar?
Of course, of course. I consider you as a part of our, our family now.
Wonderful. So if you send me a link, I will try to log in and join the webinar.
So for all our viewers, next week we have a Web Friday talk will be on Singapore laws, where Professor Van and Professor Aurelio is joining. And we also have a session planned for, impact of COVID-19 on Australian laws, where Professor Seams and Atkins Scott is joining and delivering their expert views. So my request to all the viewers is that do follow our website and do join us. It is really great to have you with us. Great questions. And if there's no further question, then I'll do the ceremonial thank you to Professor Bork. Any further questions? Okay. Would you like to give any last comments, Professor Bork, before we close the session today?
Yeah, just only to thank everybody to be interested in German law, and especially to you, Niti, for organizing this so carefully. Thank you very much. It was a pleasure.
Thank you, Professor Bork. Despite the time difference and despite we never met in person, you readily agreed to do this session for us. Can't thank you enough for that. And, as a law student, I've been following your scholarship and has been very, very inspired by what you've written, both in arbitration and in insolvency. Thank you so much, Professor Bork. Thanks to all our who joined us today. Thank all the viewers. There's so many webinars happening everywhere that I think webinars have become quite a thing to stay away from. But thank you so much. A special thanks to all the practitioners who's taken time from their work. I see Ms. Vinny Thapar, ma'am, who's our Board of Governance member. Thank you, ma'am, for joining. All our students, all our colleagues, and special thanks to my IT team. Today we had a glitch in the beginning, but trust me, error was all mine and nothing owed to the wonderful IT team, Mr. Abhijit, who's handling that. And Urvashi, who's our Senior Research Fellow with the Center. And thank you. And do log in next Friday, 2 p.m. Thank you, everyone.
Thank you and bye-bye.
Bye-bye, Professor Bork. Hope to have you again for a webinar. Thank you.